This podcast is brought to you by Customplan Financial Advisors, Inc., an independent insurance managing general agency in Canada. Financialpodcast.ca was developed with one goal in mind: to educate Canadians on important topics that affect their financial well-being and make it readily available to all. We welcome you to plug in and learn with us. If you have questions, please email us at contact@financialpodcast.ca.
Hello and welcome to the Financial Podcast. My name is Gary Poyer. Today we have a very special guest, and his name is Jonathan Ng. Jonathan practices law at Underwood Gilholme Estate Lawyers. Jonathan's focus is the preparation of wills, enduring powers of attorney, personal directives, and trusts. Jonathan also advises executors and attorneys on the administration of estates, and he's experienced in court applications concerning grants of probate and administration, and he's appeared before the court on the validation of non-compliant wills, family maintenance, and support. Jonathan is also a member of the Canadian Bar Association, South Alberta Wills and Trust Section, and the Estate Planning Council of Canada. Welcome, Jonathan.
Thank you, Gary.
Before we begin, I just want to inform our audience that today's podcast is part one of a two-part series. Today's focus will be on the basics of will preparation with an emphasis on the role of the executor and the probate process. We'll look at some estate planning strategies from a financial planning perspective. And next week, part two will focus on the use of guardians, the use of testamentary trusts, and we'll again add some additional financial planning strategies from an estate planning perspective. And as you might expect, there will be some overlap between parts one and two. So let's get started. Jonathan, estate planning is obviously a very important part of a person's overall financial plan, and it can be approached from a number of different angles. From a legal perspective, how do you define estate planning?
Great question, Gary. Estate planning refers to the transfer and preservation of wealth in an orderly and effective manner. You asked the question in the context of legal, and if I can touch on areas outside of legal, I would also comment that estate planning also involves creation of legacy and creating memory, building wealth for future generations. So certainly from a legal context, preservation of wealth and movement of assets is a big part of what we do. But from a grander scheme, I think legacy certainly deserves a shout out.
Okay, great. And what would you say is the foundation of a person's estate plan?
Well, the centerpiece of an estate plan is a properly drafted will. That's certainly number one. When we meet with a client to prepare a will, it's also common to consider the circumstance of incapacity. I know that's not our focus today, but it's always worthwhile to consider the concurrent preparation of an enduring power of attorney and personal directive document to consider preservation of wealth during life if there's a time of incapacity, and medical decision making as well. So those three documents come together with the will as the centerpiece.
Okay, so when a client comes to see you, you look after all aspects: the wills, the enduring power of attorney, personal directives, and even trusts if need be.
That's right, Gary.
Okay, excellent. All right. And from a legal perspective, what is a will?
I like that question. From a high level here, a will is a writing that declares wishes on death, generally speaking. And those wishes usually entail the appointment, the choice of an executor, choosing someone to be in charge, disposition of assets, giving wealth, transferring wealth to named beneficiaries, and on occasion also giving other roles and disposing of other property. So appointment of guardians, so choosing people to take care of minor children, appears in a will. And in rare cases, if a person is part of a corporation or part of a family trust structure, a will can be used to make certain directions for those entities. Again, not common, but certainly worth mentioning.
Okay. Yeah, well, the will certainly sounds like it's very important part of a person's financial planning aspect, I guess. And especially, you know, for business owners, I think a lot of business owners forget that if they were to pass away, their business may not just continue on. And what are some of the legal terms that come up during the preparation of a will?
So we start with the person who is preparing their will, right?
Mm-hmm.
The person who's preparing their will. The formal terms are testator, if it's expressed in the male, in the male, or testatrix, expressed in the female. So testator, testatrix. This is the individual who is preparing their will. It's an old term. We see it sometimes in wills. I don't use it as often, but we see it quite a lot. Other terms that I know we'll get into today, but perhaps worth mentioning at the top of our chat today is executor, right? The person who's involved with the administration of the estate and oversees the administration of the estate, and guardian, person appointed to have the care and custody of minor children. And then another term I put out there maybe, which I know we'll get into further, is beneficiary, people or institutions who receive assets from the estate.
Yeah. Okay. So let's say that that I make an appointment with you and I come to see you to prepare my will. From again, a legal perspective, is there anything that any criteria that I have to meet as the person having the will prepared in terms of age or anything like that?
Yes. Coming in through the door, we're making sure that you're an adult for a variety of reasons. And to be clear, that's 18 and older. Okay. Obviously, from a due diligence and practice perspective, I can act as a lawyer only for adults. And the law requires that a person preparing a will must be an adult. Furthermore, and sometimes this takes a little bit more nuance, we need to make sure that the client is of sound mind, right? Is making their decisions on their own, not surrounded by any suspicious circumstances, not subject to any undue influence in preparing their will. And this can be the topic of a whole other podcast, Gary, but the allegation of incapacity, the allegation that there is suspicious circumstances in the preparation of a will sees its way into Canadian courtrooms every day. And when it comes to the preparation of a will, a lawyer must be convinced that those circumstances are not present. And it can be complicated from time to time.
Okay, yeah, no doubt. You know, I think everybody has seen on TV or in a movie a scene where somebody's busily writing out their will on a napkin or a piece of paper. Are wills in Canada written on napkins or pieces of paper? Are they valid? And what do you call those kinds of wills?
Yes, this is commonly known as a holograph will. So despite what the name may suggest, there's no holograms involved here. What this means is that it's a will that's written out entirely in the handwriting of the testator or testatrix, right? Okay. From top to bottom. So for greater clarity here, if a person types out their will or has their will written out by somebody else and then they sign it, that is not a holograph will. From start to finish, it has to be entirely in the testator or testatrix handwriting, signed and dated. No witnesses required. And that's a holograph will. And that is valid in most provinces and certainly here in Alberta where we're speaking today.
Wow. Okay. And they're valid right across Canada or just in Alberta?
I'm gonna have to do some homework there. I'm licensed here in Alberta. I'm certainly it's valid here. I don't want to give an improper answer to the listeners.
Okay. All right. And what about the kind of will that's probably more traditional, where I, as a client, come meet you, talking about my wishes, and you actually prepare the will? What do you call that kind of will?
Well, we see many terms for this: a valid will, an English will, a common law will. At the end of the day, what this practically looks like in most cases is a document that's typewritten, signed by the testator or testatrix at the end of the document. When that signature is placed, there needs to be two witnesses present before the testator or testatrix, and those two witnesses must sign their names as well onto the document.
Yep.
The two witnesses need to be together in the room while the testator signs the will. And naturally, we need to be certain that the testator or testatrix understands that they're signing the will and is making that decision in, with a clear mind. This goes back to the earlier comments of capacity. They must have the mental capacity to prepare a will, and again, be 18 years old. And that document you have there is a valid will.
Okay. And what about the witnesses themselves? Can they be anybody, or can they be the beneficiaries, for instance, or related to the beneficiaries?
That's a great question, and it's something that unfortunately sees dispute from time to time. So generally speaking, these two witnesses should not be named in the will in any way, right? To be safe, I wouldn't want to see a witness who is named as an executor or named as a guardian. Right. I would not want to see a witness who is a beneficiary named in the will. And then I'll take it further. I wouldn't want to see a witness who is a spouse of a beneficiary, or the spouse of an executor, or the spouse of a guardian, or a spouse of anyone named in the will. So in order to be safe on this one, I generally advise, especially if people are deciding to prepare their wills on their own, to work with their neighbors, someone who's completely owned, presuming that their neighbors are not beneficiaries, of course. Right. What a kind gift to your neighbor. In any event, very neutral people. And to give further context, when I prepare a will for a client, the witnesses to that will are myself and one of my staff members in my office. We have no role in that will, no presence in that will. So that's why that client can go home with the certainty that the witnesses were completely neutral.
Okay. And what happens if a beneficiary is the witness? Does it invalidate the will at all, or what happens in that situation?
When a witness is a beneficiary as well, or maybe the other way around, when a beneficiary becomes a witness to a will, the will is still valid on its face, right? So we still have a valid will. We still have the two witnesses. So that legal requirement is met. The issue, though, is the gift to the beneficiary. So say that beneficiary was given $10,000, and then they later acted as a witness to that will. By signing that will, that gift of $10,000 is considered void. Void.
Really?
That beneficiary does not get their $10,000 gift. To put it another way for the listeners, to put it another way for the listeners, when you witness a will, you write yourself out of the will. Think of it like that. And you know what? I think that's kind of a good thing. It's funny. I tell this to clients when we're signing our wills. They often make a funny joke. They say to me, "Hey, you didn't sneak anything in for yourself, did you?" And I say, "No. And if I did, I invalidated it by witnessing the will." So that gives you the peace of mind that I didn't sneak anything in. So it seems intuitive to do this, but it happens, Gary, all the time, especially when we have individuals preparing their own wills under maybe a stressful circumstance. They're preparing a will on their own on the eve of a surgery. Perhaps they're very sick and they're trying to put something together fast. And it just makes sense. Hey, I'll ask my husband, I'll ask my wife to witness the document, because he or she is here every day at the hospital and the nurses don't want to touch it. They've been briefed on the liability there. So they ask their brother, their husband, their daughter to witness a will, and then inadvertently they've written their loved one out of the will.
Wow, that's crazy. But I'm sure that people take wills or the situation concerning the will to court all the time to challenge that. I would think. Do they not? Or
Yes. I've brought, for example, matters to court where a couple times. Where it was inadvertent, right? There's no funny business here. A person prepared their will. Frankly, it was I don't like this term, but deathbed will sort of situation. Yeah. And they brought in a family member to witness just because there weren't a lot of people around. And what I asked the court after that person died was, court, can you validate this gift? On the face of it, it's a void gift, right? Because the beneficiary witnessed. But based on the circumstances, and I got to give a whole bunch of evidence and supporting evidence from the other beneficiaries, I asked the judge to let that gift flow. And thankfully, in those cases, it did happen. There was no contention. Everyone agreed that this was an accident. And the court has the authority, among other powers, to validate these these mistakes, these oops situations. And there's provisions in specifically in the Wills and Succession Act here in Alberta, section, I believe it's 37. And there's a similar provision in other provinces where courts can look at wills where there is, for example, only one witness, or a void gift, like we talked about here. And a court can say, based on the facts, we will fix this. We will rewrite that section of the will. We will resurrect an otherwise void gift. So, I don't wish it for families that they need to use these provisions in the law to fix these mistakes. So it always goes back to the beginning, right? Let's get it done right the first time. But if, heaven forbid, something is not prepared properly, there are ways to fix it in court later.
Right. Okay. That actually leads into my next question. Considering a will kit, because you hear a lot about will kits, and they're available at Chapters and Indigo and Staples and places like that. What are your thoughts on a will kit?
Mm-hmm. I guess the first thing I'll say is, if a will kit is usually better than no will, right? If a person is in a circumstance where they're in a pinch, they don't have a lot of time, maybe they're not in a position to lay out the expense, right? To work with a lawyer or notary on the preparation of their will. Some people are very private, and maybe they can afford it. They have the time, but they're very private. They're not comfortable sitting down with even their own lawyer to talk about these things. These are all circumstances where a will kit is probably better than nothing, and a will, and certainly better than just taking out a blank sheet of paper. The will kit is normally quite instructive. It comes with instructions. It tells the testator or testatrix what to do. It gives them a little bit of advice, which I want to talk about in a moment. It gives them a little bit of advice, and most of the time the instructions are quite clear on how to sign the document, right? Invite 2 witnesses. Here are people who can and cannot be witnesses. Make sure they're in the room with you, and follow the process. The issue, though, I find is the lack of advice, right? When a person hires a lawyer or a notary to prepare a will, they're not paying for paper, right? They're not paying for the words per se, right? Because if that was the case, a will is about 15 cents. What they're paying for is advice, right? They're paying for consultation on who would be a good executor or guardian, or how to dispose of assets properly in an efficient way. A will kit has some pointers there, but it can't dialogue with a person. You can't have a conversation with an instruction book, right? So that's where a will kit has its flaws. But again, if it's a question of no will versus a will kit, and provided that the circumstances are fairly straightforward, and I'll throw out some circumstances in a moment, then a will kit is the way to go. And circumstances could be blended families, ownership of multiple properties, complicated trusts, disabled beneficiaries. I can go on. These are areas where maybe the will kit might not be as strong. Yeah,
I can certainly see that, because with the number of blended families nowadays, or business owners, I just can't see a will kit being comprehensive enough to really serve the client properly. Okay, so let's say that I come and visit you, Jonathan, and we prepare a will for myself. Can I then make any changes to my will, or is the will basically cast in stone?
A will is, get ready for the cliche, it's a living document.
Yeah.
It's a living document. I know it's such a cliche, but it really means something in that a will can be updated. It can be revoked, and then a new one can be written. Sections can be removed and replaced with new sections. So that's something that I want everyone to remember, right? I think there's this idea that when you write your will, you're going to die the next day, and then this is it. But no, not the case. You can update your will at any time, as long as those requirements are met, right? Of course, you still have the mental capacity to prepare your will, and that goes into a whole other chat for another day. So the ways that a will is changed are varied. A common way to do it is to write a new will, and that's, in most cases, my go-to advice for a client. Let's just write a new document, right? That way you can capture in time today that the entirety of this will is what you want to be done. And if they're a returning client, Word processing has made that dead simple, right? I open up the Word document from when they saw me 7 years ago, and I implement the changes. It's relatively cost effective, time efficient, and there we go. So a new will revoking an old will, even if it only changes a few sections, is quite efficient, and that is what I generally suggest. There's another document known as a codicil or codicil.
Okay.
This is a document that's designed to be written after a will is prepared. So, for example, you have a will from 1997. Here's a common situation, Gary.
Okay.
Let's say an individual has a will from 1997, and they want to change executors. Everything else in that will is to his or her satisfaction. But that testator or testatrix wants to change their executor from their brother to their cousin. Okay. And say it's a complicated will beyond that. It's a 20-page, legal masterpiece here, and all they want to do is change one line or one paragraph. So what a codicil is a document that says, I, testator, on this day, remove paragraph 1 and replace it with this new paragraph 1, which now reads as follows. Furthermore, I confirm that the rest of my will is what I want. Signed, 2 witnesses, same protocol as a will. And then there you have it. You have a will next to a codicil. And when married together, or as they sit together, they read as one document. You can see, however, warning here for everyone, that it could get complicated. I've met individuals with the help of lawyers, or sometimes on their own. They'll pass away with a will and 5+ codicils, a Frankenstein of a will. Wow. And it's hard to deconstruct and reconstruct what they're trying to do, when in hindsight, we say to ourselves, gosh, I wish they just rewrote their will into one fluid, simple, easy to read document. So the codicil, there's a time and a place for it. But generally speaking, if the circumstances are right, and most times it is, preparing a new will is the way to go.
Yeah. What happens, and I'm sure this has probably happened, if somebody changes their executor, like you were just mentioning, they take out their pen, cross out their old executor's name, print in their new executor's name, initial it, have the same witnesses initial it. What would happen in a situation like that? Okay.
So these are, as alterations or revocations. And it is possible, at least certainly under Alberta's Wills and Succession Act, to alter a will in that fashion, right? So I'll get right into the specifics here. If a person wanted to change a will that was originally witnessed by 2 people, right, a traditional kind of will in writing, typewritten, and they want to make an alteration, the alteration can be made directly on the document, the strike through, just as you described, Gary. They should sign that change, date that change, and 2 witnesses. It does not have to be the same 2 witnesses, by the way, but 2 witnesses must witness it.
Okay.
And on the face of it, we are in compliance with Section 22 of the Wills and Succession Act. But I'm sure the listeners and yourself, Gary, are imagining just how messy that can actually look, right? And although it's it's sort of an old phrase, just because it's illegal doesn't mean you should do it.
Yeah.
If you're in a pinch, going into surgery, sure, right? And about to jump on an airplane, sure, why not? But hey, if you come out of that surgery okay, if you come back from that trip okay, let's do it the right way, right? Maybe a codicil, or if you can ask the lawyer who prepared that will to punch up that old Word document and print out a new will with that change now flowed in, let's get that done.
Yeah, well, I would think that clarity is important when it comes to settling an estate, right? You don't want any uncertainty out there, and just like with investing, investors don't like uncertainty, and probably beneficiaries don't like uncertainty as well. A couple more questions. These situations happen all the time. So let's say that I have a will and I then get married. What happens to my will? Is it still valid, or what's the situation in that case?
Yes. Now, this is a question that's going to speak to the difference in wills and estates law from province to province, because your question has a different answer in different provinces. And I'll be careful to not answer on provinces that I'm not entirely sure of. But let's start with Alberta. So again, the question is, a person prepares a will on a given date. Down the road, they get married. And then I guess they pass away, right? Obviously.
Okay.
So we ask ourselves, what happened here? How do we interpret this will? So there was a time here in Alberta where marriage revoked a will. So again, following that narrative, write a will on a given day, married the following day, died the next day. That person died without a will. That marriage served to revoke that will. All right, listen, everyone, that is no longer the law in Alberta. That was abolished in 2012 through our Wills and Succession Act. So the will continues to be the will. There's a few catches to that. I'll get to that in a second. Ontario abolished it only last year, I believe, 2021. Ontario got rid of that rule. So Ontario had that rule for quite a long time where, again, marriage revoked a will. I'll speak to just those two provinces where I have certainty. And if any listeners want to contact me, I'm happy to check the law in the province where they're at to see what the rules are there. But again, here in Alberta, marriage does not revoke a will. But let's play it through. Let's play it through here, Gary. And without at the risk of opening up a can of worms here. So let's say a person writes a will saying, they're single at the time. I give my estate to my parents, right? Maybe a young professional, they're playing the field and they want to benefit their parents. How kind. They later meet someone and marry them. Okay. And they have a great life and marriage together. And then, unfortunately, that individual, the testator dies. Okay, so how do we deal with these facts? Marriage did not revoke the will. So that person passed away with a will saying, I give my estate to mom and dad.
Right.
But herein lies the issue. They left a surviving husband or wife or partner. And this introduces a whole set of concerns, and this has a different name for every province, but here in Alberta, this is a concern that touches on family property and family maintenance and support. Basically, we've got someone who gave everything to their parents and left their husband or wife with nothing. Now that husband or wife or partner can raise their hand and say, that will was not fair. Now note, the will was still valid, but it's not fair because they cannot live their life properly because half their assets were shipped over to their in-laws. Right? So again, it's a conversation for another day, but I guess the takeaway here is, although marriage does not revoke a will in Alberta, marriage should prompt a person to revisit their will and make sure their will fits their interests, fits their wishes, fits the fact that they are now married and might have children.
Right. So that's very interesting. I thought in Alberta, marriage did revoke the will. So I'm glad you clarified that for me. And I'm sure you clarified it for a lot of financial advisors that are listening as well. Okay, so on the flip side now, let's say that I have a will and I'm married, but then I get divorced. How does that impact my existing will?
Great question. Great question. You had to start with marriage and end with a divorce, Gary. It's very elegant the way. So, all right, let's go with those. Let's reiterate those facts. You write a will, and we'll say, presumably, the person who writes this will says, I give my estate to my husband or wife or partner. Very customary, very common to do that. Marriage breaks down. Divorce is finalized. And then the testator dies with that very same will, never reviewed. It still says, I give my estate to my husband. Long divorced. He's gone, right? Okay. So let's start with the will itself. Is the will valid? Yes. So divorce did not invalidate that will. That person died with a valid will. And yes, that will still says, I give my estate to my husband, who's now an ex at the time of death. So we are to interpret this will as if that husband died before the testator.
Really?
Yeah. When I tell clients this who came out of very contentious divorces, they love hearing that we treat their husband as dead. So divorce killed the spouse in the terms of the interpretation of the will. Okay. So we now read the will as if that person is deceased, and most wills have a plan B. So let's follow this example. Let's imagine it's a lady who wrote this will saying, I give everything to my husband. They divorce. She later dies. We now read the will as if he's dead. So she possibly said, if my husband is not alive, then divide my estate equally between my 3 children, for example. So in this case, the estate would flow to the 3 children. We treat him as dead, and those 3 children are the beneficiaries of that estate.
Very interesting. Which actually brings up my next question. Is a will, like when somebody has a will prepared, can anybody go and read that will, or is it a public document, or is it a private?
Well, while a person is alive, right? So while the testator or testatrix is alive, a will is private, right? Arguably, the only person entitled to see that will is the testator or testatrix. And I hope that gives comfort to all the listeners today, right? This is your will. This is private business. And you are entitled to revoke and write a new will at any time, right? So that's why it's the sanctity of privacy is a huge deal, right? In wills while a person is alive. Quick comment. I know we're not talking about powers of attorney, but if someone is acting as a power of attorney, a legal financial decision maker for a testator, they should have a peek at the will to make sure that they're not disposing of assets that are mentioned in the will. Okay, I'll leave that point there. Maybe we'll talk power of attorney another day. But generally speaking, while you're alive, the will is your private document. After death, it gets a little more complicated. So the will, generally speaking, continues to be a private document, but there are some people who are entitled to see it. Let's start with the executor. The executor should see it because they got to know what work they're doing, what's ahead of them. Beneficiaries of the residue. I know we didn't talk about that, but the properly written will, structured will, should say, I divide what's left in my estate equally among, for example, my 3 children, right? These are known as residual beneficiaries. They receive the bulk of the estate after taxes, debts, and gifts have been handed out. So again, residual beneficiaries, all properly written wills should have residual beneficiaries, sometimes just known as beneficiaries. These individuals or institutions after death are entitled to see the will, and rightly so. They should know what's coming to them, right? And to take it further, they should be able to query with the executor, hey, how's the estate going, right? There's something flowing my way. I kindly ask for an update. Anyhow, so residual beneficiaries have a right to see it. Now, here's the interesting thing. So that seems like a pretty limited group, right? The executor gets to see it, maybe the guardian, residual beneficiaries. For some estates, this could be a handful of people. Well, here's the kicker. And I know we'll talk about this in a moment, but there's this thing out there called probate. And it has different names in different provinces, but here in Alberta, probate generally is the process of having this will validated by the court. It happens all the time. It's a very common step in the administration of the estate. The will has to be submitted to the court for validation. And we'll get into the details later, but in doing that, the will becomes a public document. Court records are public documents, right? The court is public for people to be involved with and to be aware of, right? This is part of our society. So when a will is submitted for probate, which it commonly is, it becomes a public document. So whether you're the executor and a beneficiary or a nosy neighbor who lived across the street, they can go to court and ask to see the probate record and ultimately take a look at the will.
Wow. I wonder how many people understand that. I guess, if you're dead, it doesn't matter. But family members, I think, would probably still be concerned. But Jonathan, I just want to ask you some scenario type of questions because I'm a financial planner, and I know a lot of financial planners will sit down with their clients, talk about estate planning. And a lot of times, the discussion concerns the transfer of assets in order to try and minimize probate fees. But financial planners aren't lawyers. So in what situation, or what is your opinion, your legal opinion concerning different scenarios? Like, for instance, if I sit down with a client, talk to them about how they should have assets designated, using life insurance or RSPs. From a legal perspective, is there any issue in doing stuff like that, or is the financial planner well within their right to do that?
A financial planner certainly is in the right to do that. I think the financial planner who is, presumably, obviously carrying the proper designations and the training to properly advise a client on estate planning is in a position to explain what a beneficiary designation is, how it works, how it's actually administered after the person passes away, how joint accounts work. These are all estate planning tools that stand alongside a will. My view from I guess the legal perspective, but even just as a person, right, as an individual here in this country who writes their will and plans their own estate, is to always look at the big picture. And I guess to the advisors out there, always look at the big picture, right? If you're counseling a client on designating an RSP or a TFSA to a certain individual, query with the client, well, what does the will look like, right? What's the overall plan? Because is this person trying to hand out some assets to some people and others to others? And they're in the right to do that. But again, help our clients know what the big picture is, because it is not uncommon that a will says certain assets go there. The estate, quote unquote, the estate which the will controls goes to certain individuals, but other assets, perhaps life insurance, beneficiary designated life insurance, goes to other individuals. The client fully understands what they're doing, so be it. But it's not uncommon, and unfortunately, I've seen situations where we will see a disconnect, an incongruence. Oh my gosh, why did I name my brother as the beneficiary of life insurance when my children are the beneficiaries of my estate? Let's follow that example. Well, I kind of want my brother to informally receive all that money because he's going to raise my kids. Okay, here we go. At the end of the day, this person is saying to me that they want their children to be in the care of their brother, and they want their wealth to be dedicated to the raising of their children. All right, so what they're doing then is going off the books and giving some money to the brother and informally asking him to use that money for the kids. For some families, that can work very well, but on the face of it, that's improper. He can go to Vegas with that money. He can buy a Lamborghini for his troubles, right? For taking on these stinky kids. Not to drill in too deep to that scenario. There's ways to work around that, right? Those assets classically should be essentially given to the children in trust. That can be managed through the will so that the money is available to the children and maybe even in the control of the brother, but legally goes to the children through testamentary trusts. I know this opens up a can of worms here. You know, we're now putting money into the estate. Are we causing probate fees to be elevated? Well, here in the province of Alberta, absolutely not. Our probate fees are capped at $525. This is a huge reminder for our Alberta advisors that the drive to limit probate or limit probate, eliminate probate, limit probate fees, in my view, is a bit of a myth. And we really should ask ourselves, why are we eliminating probate? Why are we doing this? It's certainly not about fees, because here in Alberta, it's a capped fee, $525. But in other provinces, certainly something to be cognizant of. 1.4, 1.5, 1% of the estate value could be taxed. So again, even applying this issue of life insurance, there's ways to use trust planning to get that money to the kids with the uncle as trustee and eliminate probate taxes. You can have your cake and eat it too in BC, but proper planning and thinking about big picture is the takeaway here.
Yeah, excellent. Just a couple other scenarios real quick. If a financial planner counsels the client again on the preparation of the will and the estate planning, and ends up being a beneficiary or the executor of that client's will, it sounds like it's a conflict of interest, but from a legal perspective, what are your thoughts on a situation like that?
Well, I guess I'll jump right to a very, very brief anecdote and tell you, Gary, I've seen it. It's happened, and it worked. Okay, not to say it'll always work, because there's a lot of considerations that I'll try to introduce, but yeah, it's possible. Because let's play it out, right? We have a client and their financial advisor. They have a great working relationship, and maybe they've even become friends. And they go to their kids' birthday parties, they golf together, they're friends. But yes, concurrently, there's this fiduciary role of acting as advisor as well. So that testator, the client, goes to their separate lawyer of their choosing, right? And later instructs that lawyer, hey, prepare a will saying, I choose my best friend, Gabrielle, to be my executor. She's also happen to be my financial advisor. And I also want to give Gabrielle a gift of $25,000. right, in my will. That is just fine. The lawyer will make sure, of course, that Gabrielle is not a witness. That would be highly improper and very odd anyway. So the lawyer will have the proper witnesses signed. It's a done deal, Gary. That's going to be fine. But here are some of the concerns, certainly. You can tell I massaged my story to make sure that the lawyer is independent, right? From the financial advisor. And just the very fact that it is a lawyer, right? It's not a will that Gabrielle cooked up because she knows a little bit about wills and she wrote it up for her client. That would be an issue. So again, the will prepared independently by a lawyer helps the situation work. Gabrielle, of course, is not a witness. That's the usual rule there that we talked about earlier. But this is a piece where I don't want to step out of my lane. This is something maybe you can comment on. Pressure's on now, Gary. But that financial advisor should probably check with their regulating authority, whether it's financial plan, if they're a financial planner, if they're a life underwriter, financial analyst, work with your respective regulating bodies and make sure you can take this job. From my understanding, a person can certainly do this as a friend, but they can't do it as an advisor. And I know there are some lines there. Any comments there? Pressure's on, Gary.
Well, I know that a lot of financial institutions write in their compliance manuals. It does state that financial advisors should not be executors or beneficiaries because it is viewed as a conflict of interest. And when you stop and think about it, it really is a conflict of interest. You can advise the client on a lot of different areas of financial planning, but you always want to have that, that distance that in the relationship between you and the client. In Alberta, especially with a lot of people being involved in the oil and gas industry and then BC as well, a lot of clients will have assets outside of Canada. What kind of a will should be used, or what is the best way to set up a will in a situation where clients have assets outside of their local jurisdiction?
Sure. I suppose I will narrow the facts to a few scenarios here because there's sort of sub scenarios that need to be addressed. Okay, what am I getting at? Use the word jurisdictions. Let's start there. From an estate standpoint, jurisdiction is defined by province. Okay, so when we're looking at broadly speaking, out of jurisdiction, foreign assets, it can be like I'm sitting here in Alberta. It can be farmland in Saskatchewan is considered foreign. Okay, and that's generally the rule across the country. That's how we view assets. So we have to be cognizant that out of province is foreign, and then even further foreign is out of country. Okay, so I want to speak to all of these two scenarios: out of province and then out of country. Okay. So let's start with out of province. It's generally speaking, and I'll put myself out there and say this to the listeners. Yes, a will prepared, for example, here in Alberta does have authority in a province outside of Alberta. Okay, it does work. Okay. Right now, it depends on what you're trying to do, though, and we're normally talking about the context of real estate. It's normally real estate because all other assets can float around, right? It's not like I have an Alberta bank account with CIBC and a Toronto bank account with Scotia, right? This is known as personal property. It floats around. It's not situate. It's not stuck to the ground, right? Mm-hmm. We're talking about out of province foreign assets. We're talking about real estate. So again, a Saskatchewan farmland while the person lives in Alberta, that's their foreign asset. If they're simply trying to say, I give to my brother my Saskatchewan property. Mm-hmm. This is an Alberta will written in Alberta by an Albertan. That's just fine. That's going to work, generally speaking. Mm-hmm. But if that individual was trying to get a little bit more fancy and was going to do some things with that property, maybe distribute it in trust to certain individuals and maybe bring in the whole can of worms of farming rules and taxation, it might be a good idea to review that will with a Saskatchewan lawyer to make sure that will and the wishes in that will be compliant with Saskatchewan land law and Saskatchewan estate law. right? Will's law. So I guess the takeaway here is a will, generally speaking, will work across the country for real estate, right across the country. But depending on the circumstances, it's worthwhile getting advice from a lawyer in those respective jurisdictions if we're getting kind of fancy with the wishes. Now let's step outside of Canada and go to say Florida. Someone owns property in Florida. So foreign assets now in another country. It's international at this point. Generally speaking, the same rules apply. I intentionally chose the United States because they have a similar set of laws across the states. And again, it's also state by state. Florida is not the same as Arizona and not the same as Texas. But generally speaking, our wills here in Canada do have legs there in Florida and across the United States, but it's the same idea. But the risks are not risks, but the concerns, I suppose, are a little bit higher because across Canada, our laws are very similar. It gets a little bit different in the United States. So same rules apply, same advice, right? Giving a property to someone, identifying Florida property, identifying a person to receive it can work, but it's worthwhile getting advice down there to make sure that it's compliant. Furthermore, in that example, the Florida lawyer might have different types of, might have suggestions to say, hey, you can do this without a will. I'm not sure with Florida, but I'll identify Arizona. We do a lot of work with Arizona, being here in Alberta. There's something called a beneficiary deed. Essentially, it's possible to own a property in Arizona, okay? And you can sign essentially a land transfer that only takes effect on death, right? So imagine it says to my brother, right? And then this document is filed. It's like a little mini will that says this property upon my death automatically goes to my brother. No will needed, right? And that brother is not a joint owner. That brother has no rights until I die. And I can change that beneficiary deed anytime I want. It's a great, great tool I've seen in Arizona. I would not ever counsel someone on how to do it because that's just not my area of practice. But this is a great example where someone who wants to explore beneficiary deed should speak with an Arizona lawyer. And then, of course, as you can probably presume, this advice stretches further around the world and the risk goes higher, especially when you go into countries where they do not have an English or common law system, especially when they have if it's a country where English is not an official language of the court. See, now we have an issue where we have a will that might not be congruent with their day-to-day language, might not be congruent with their legal system. So this gives rise sometimes to a will written in that jurisdiction alone, just in Germany, dealing with that German condominium, because our wills are written a little bit differently, different set of laws.
Yeah, well, that's a lot to think about if you own property outside Alberta. You know, even if it's just in Saskatchewan, certainly in the States or Germany or anywhere in Europe or Asia, I would think. Okay, Jonathan, well, thank you very much for all the information you've given to us today. That brings us to the end of our podcast. I also want to say thank you to Customplan Financial Advisors for being our sponsor. Customplan is an award-winning managing general agency providing fantastic resources to the independent financial advisor. Please check out Customplan Financial at customplanfinancial.com. This podcast will soon be up on YouTube and Spotify. And again, you can come across it at financialpodcast.ca. Sign up or subscribe to our podcast. And if you know of somebody who would make a great interview, please let us know at contact@financialpodcast.ca. We'd love to have your feedback. Thanks again, Jonathan, for being our guest. And just a reminder that Jonathan will be our guest for our next podcast. And before I forget, Jonathan, please give us your contact information.
Sure thing. You can find us at willsandestates.ca. We are Underwood Gilholme Estate Lawyers in Calgary, willsandestates.ca. Thanks, Gary.
Okay. Thank you again, Jonathan. And we'll see everybody else next for our next podcast.
The views expressed here are those of the participants and not those of Customplan Financial Advisors, Inc., its affiliates, or subsidiaries. This is not intended to serve as a complete analysis of every material fact regarding any company, industry, or security. This presentation may contain forward-looking statements. Investors are cautioned not to place undue reliance on such statements, as actual results could vary. This site and podcasts are for general information purposes only and does not constitute investment advice and is not intended as an endorsement of any specific investment product or service. Individual investors should consult with an investment professional about their personal situation. Past performance is not indicative of future results. If you are unsure about what is the best course of action for you in your financial planning, then we suggest you consult a fee-based independent financial advisor or get in touch with us to discuss your individual situation. Our phone number is 604-687-7773.